Your medical malpractice case goes all the way to trial. And during the course of your trial, you are getting so frustrated. Why? Because the defense lawyer keeps objecting over and over and over again. Objection, Judge. He jumps up repeatedly. Objection, Judge. And now, over and over again, not 5 minutes go by before you see the defense attorney jump up out of his chair and yell out, Objection, Judge. And now you want to know, is this normal? Can you do something about it? Can your attorney do something about it? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is you can't do something about it, but your attorney can. What can he do? He can object to the judge. He can make a comment to the judge. He can make a comment to the jury. He can show to the jury that this attorney is simply making objections. Why? As a strategy to divert the jury's attention. That is a possibility. Now, he'd have to show a pattern. He'd have to show that this is being done repeatedly. But guess what? Sometimes the better practice is not to say anything at all. You want to know why? Even though you may find it frustrating sitting in the back of the courtroom watching the proceedings that are going on and seeing the shenanigans that the defense attorney is doing, jumping up out of his chair, you're wondering, why can't he just let these questions go? Why can't he let the evidence in? Why does he have to fight about every damn thing? Well, the fact is, he may actually be doing a service for his client. He may have an obligation to actually go ahead and raise an objection when he honestly believes, that the question is improper. Honestly believes that the question should not be answered because of some legal issue or some legal ruling that has been made in the case. That's a possibility. There is also the possibility that the attorney believes that each of these questions that are being asked are for some reason improper. And now it is up to the judge to make a ruling of law to decide whether these objections are in fact accurate. You keep saying, why can't you just have a smooth trial where your attorney asks questions, he admits evidence, and now it's then his turn to go ahead and cross-examine? Well, that's not how it works. Because if an attorney honestly believes, that there is a problem with the question or a problem with certain evidence, he has an ethical and a legal obligation towards his client to stand up and make that objection to the court. To say, hey, judge, there's something really wrong with this question. It should not be asked this way. The judge then has to rule on that request. Is he right or is he wrong? Now, if there's a piece of evidence that the attorney believes should not be admitted into evidence, now he has to tell the judge why. The judge then has to make an immediate ruling about whether he agrees with the attorney or not. And you will find that those objections, those repeated objections, clearly interrupt the flow of your attorney's questioning. Now, I have to share something else with you. There are some instances where some defense attorneys make objections, repeated objections, as a clear strategy to get into the mind of their opponent, to disrupt them, so that now when they get back to the question they were supposed to be asking after the judge has ruled, now they're thrown off track. Now they've lost their momentum forward. And now it's like, shoot, what do I do? And the jury looks at your attorney and wonders, why doesn't he understand what's going forward? Why is he so confused at this point? He may be confused because he was focused on the objection, focused on arguing with the judge about that objection, and now he has to get back on track to try and remember what he was asking during the course of his questioning. So, is it ever appropriate for an attorney to jump up out of his seat over and over and over again? The answer is maybe yes, and then again, maybe no. So why do I share this quick information with you? I share it with you just to give you an inside look at what goes on in these medical malpractice cases here in New York. You know, I do recognize you're watching this video because you likely have questions or concerns about your own matter. Well, if you have not yet started a lawsuit and are thinking about bringing a case here in New York, and you have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.